Let's bring in National Trial Attorney Mackenzie Joy Brennan and former prosecutor Jeff Gold, both with us this afternoon. Here we go. Let's talk about tomorrow, the closings. Put your prosecutor hat on, if you will, Jeff. What are you going to push to this jury in terms of your major themes during the close?
I think they had a lot of data, a lot of scientific evidence. I think they did a very good job, and the prosecutor is going to give the jury what juries these days want, which is a lot of data. And I think the data's on their side. The defense is not really going to be able to rebut it or say that there was a third person that did it, because they really didn't put any evidence. They almost abandoned that theory to simply say that there's a lack of evidence, a bad investigation. So I think that's where I'm going to focus. I'm going to give them CSI as best as I can in this case. There's no smoking gun, but if you watch the testimony, I think the Commonwealth did a very good job, step by step, sometimes second by second, with the phone data, etc., of explaining what happened. And I think the defense is going to have a hard time coming up against this trial.
Mackenzie, if you're Alan Jackson, what are you going to do in your close?
Well, yeah, I think you're right that not having the third-party culprit is difficult. I think that they lost a lot of the public social support for this conspiracy theory when they changed their theory. It potentially is better on legal solidity, but it is challenging without that to make their alternative theory case. I would disagree that the data really favors the prosecution, though. I think that in terms of, Welch's evidence, that to me is so consistent with a three-point turn, and who hasn't been backing up in a three-point turn in the snow and it accidentally accelerated? So even those pieces of data, I think, are easily skewed to any theory that's not second-degree murder. And so, since for the defense that is a victory, obviously they're going for fully innocent, but I think it's really going to be challenging for the prosecution to prove that there was intent or malice here on Karen Reed's part, and that the defense then can really jump on that in their closing.
Jeff, how does the high-profile nature affect human beings, meaning jurors? Because let's face it, they know that this community and to some extent this country is watching, and this is their decision is going to be absorbed and reacted to in vastly different ways by a lot of different people. What kind of pressure does that put on these individuals who ultimately will end up being deliberating jurors?
Certainly does put a lot of pressure on them. There's protests out there. They're well aware of it. They've been instructed. They've probably seen it. But the second trial doesn't go for defense as well as the first, usually. The shock, the shock of Furman being a racist in O.J. Simpson's case. You work that in the first trial, and by the second trial, although civil, not so much. Same thing, I think, here. I think that the focus is not as dramatic as it would have been. In fact, the defense made a blunder here, talk about text, they made a blunder allowing texts in that otherwise wouldn't have, saying that that she had more of a motive than the Commonwealth could have proved before. I just don't think it has the impact the second time around as it did the first.
Yeah, and I'm sure in the close we're going to hear from Karen Reed in the Commonwealth's presentation. Those clips will likely be brought back for the jury to absorb. She didn't take the stand, but boy, the jury sure got a feel for her, courtesy of those interviews that she did. Coming up, we'll take a closer look at the Commonwealth's case in chief against Karen Reed. And then we'll talk about it. And as we get ready for tomorrow, the showdown between Jackson and Brennan at 9 a.m. sharp Eastern. Stay with us.
Tonight on Closing Arguments, we're getting ready for the closing arguments in the Karen Reed retrial of the century. Which side will the jury believe?
Closing Arguments tonight at 8/7 Central, only on Court TV.
Friday night, the WNBA is on Ion. The Sky take on the Dream in the air.
She's starting to cook.
Then the Wings fly out west to battle the Aces.
Vintage Chelsea Gray.
Coverage begins Friday night at 7. Find Ion wherever you watch. Ion, it's on.
Welcome back to Court TV Live. Here's a look at some of the other cases that we are, besides Karen Reed, tracking at Court TV. In Arizona, it's day 2 of deliberations in the Lori Daybell conspiracy murder trial. She's accused of plotting with her brother, Alex Cox, who's now deceased, to kill her niece's estranged husband. In New York, the sex trafficking trial for Sean Diddy Combs is continuing. Back on the stand for a 6th day is Combs' ex-girlfriend known as Jane. And in South Carolina, we're expecting to hear from Megan Jackson's co-defendant in the Corner Affair murder trial. You can stream that trial live on CourtTV.com. We'll update you on all of these cases throughout the day. But right now, let's head back to Massachusetts and Karen Reed. Court has ended for the day. The jury didn't have to report today. They'll be back tomorrow morning, though. 8:45 sharp, says Judge Canoni. She wants the closing arguments to start at 9 a.m. sharp because she wants the jury to start deliberating tomorrow afternoon. Give them a chance to sink their teeth into their deliberation and that process before they head off for the weekend. We're anticipating the closing arguments, so as we do that, let's take a look back at the two sides. We'll start with the Commonwealth's case against Karen Reed.
You will learn that on January 29th, 2022, when the defendant and Mr. O'Keefe were in front of 34 Fairview Road, you will learn that Mr. O'Keefe got out of the car and he stood by the side of the road. After an argument with the defendant, she clipped John O'Keefe. He fell backwards, hit his head, broke his skull, and she simply drove away.
Karen Reed is not guilty of hitting John O'Keefe with her SUV. There was no collision. She's the victim of a botched and biased and corrupted investigation that was never about the truth, folks. It was about preserving loyalty.
Did you receive a phone call?
Yes, from Carrie Roberts. She said John was found in a snowbank. They don't know what happened.
And at some point, you ran over to where Miss Reed was.
Yes. EMTs were around, and they were working on the body. She was running around and saying, did I hit him? Did I hit him? Is he dead? Is he dead?
There was a woman next to us who told her to calm down, stop talking, calm down, you're hysterical. So she repeated, I hit him, and a police officer asked her, said, you what? And she repeated it again, I hit him.
At some point, were you with the defendant when she spoke to an officer and a first responder?
Yes. She told the first responder, I hit him, I hit him, I hit him.
Was it important to you, before you testified, to tell these jurors, under oath, that my client said, I hit him 3 times?
As a juror, as a witness, it's important to tell the truth and to answer the question you were asked.
And in point of fact, in your entire grand jury testimony, you never said, my client said the words, I hit him, did you?
Again, it's 227 pages.
Ms. McCabe, you were there. They're your words. I'm not asking you to rehearse something. You were there. Did you tell the grand jurors that my client said I hit him?
I have testified a number of times, but I was there the morning of January 29th when your client said, I hit him, I hit him, I hit him.
The defendant stated that she dropped Mr. O'Keefe off at 34 Fairview. She did not see him go in the house. She was asked about the damage to her rear taillight, to which she stated, quote, "I don't know how I did it last night." She stated that she made a 3-point turn and left.
When you came out of Meadows, did you have a chance to look at the defendant's taillight on her Lexus?
Yes. Karen pointed out and said, "Look, my taillight." And she said, "Do you think I hit him?"
Do you recognize that item?
Yes.
Is that one of the items you bagged that night?
Yes.
That night, do you recall if there was any other pieces of taillight recovered?
I believe in total we located maybe 6 or 7 pieces of taillight.
What type of work were you assigned to do in this case?
So I was given items of plastic for comparison. The red plastic that I sampled from the debris from the clothing was found to be consistent in color, microscopic appearance, and instrumental properties with the portions that I sampled from the red plastic from the taillight.
He didn't look mortally wounded as far as I could see, but could I have done something that knocked him out and in drunkenness and in the cold didn't come to again?
And this would have been the moment you dropped him off at the party.
Yeah, would have had to.
His body was completely covered, but his head was completely covered, so I started to dig around his face and his eyes, and his left eye was fine, but his right eye looked like it was huge, like he had something happen to it.
There were a series of cuts and bruises to the right arm. There was also a bruise on that same arm on the back of the hand.
The location and orientation of the laceration on John O'Keefe's right forearm and arm are consistent with the geometry and orientation of the right taillight of the Reed 2021 Lexus LX 570.
Did you come to a conclusion about the manner and cause of Mr. O'Keefe's death?
The cause was blunt impact injuries of head and hypothermia, and the manner was undetermined.
What was the total snow accumulation from the storm in its entirety?
23.8 inches.
So just short of 2 feet, is that correct?
That's correct. The ground was frozen. The soil was frozen, and the surface of the ground was frozen. And it would have made the ground impenetrable.
Why did you go back to the spot where John was lying when you first saw him?
When they lifted him up, there was grass underneath him, and I could see his phone.
At 31 minutes and 56 seconds, we start the health event that shows 36 steps were taken. The message, "Pull behind me," is red. 32 minutes and 9 seconds, the message's application is closed, and the device is locked for the last time.
At 12:53, that's about, 21 minutes or so after that phone stops moving? What's the temperature?
61 Fahrenheit.
You mentioned that you were looking for time information or power on information regarding 2 events.
Correct.
Can we characterize those events as text stream events?
Yes, we can. That second text stream event is a backing up maneuver.
When you looked at the time from the Lexus clock regarding that backing event, did you do an analysis of John O'Keefe's phone?
Yes, I did.
When you apply that variance between the Lexus clock and Mr. O'Keefe's phone,
The time of that event with the clock variance adjusted is between 12:32:04 and 12:32:12.
You would agree that there's not even a degree called Bachelor of General Science in Mathematics and Business Administration offered at the University of Alabama, correct?
Correct. That should be Bachelor of General Studies with minor in Mathematics and Business Administration.
And what you just articulated, you do not possess as you sit here today, correct?
That is correct.
just a few days before this incident, you were aware that Mr. O'Keefe asked her to leave. but you wouldn't.
At 12:37:08 a.m., the defendant calls John, and voicemail number 1 is left. 12:59:24 a.m., the defendant calls John, voicemail number 3 is left.
John, I'm here with your kids. Nobody knows what the you want, pervert.
Do you know if there was any jealousy in that relationship?
Karen wouldn't let, I mean, they did everything together, a lot of things together, and I thought at times, yeah, you could see, you know, she didn't want other women around John.
The niece of the victim, Officer John O'Keefe, she took the stand today. She was soft-spoken as she talked about the breakdown in the relationship. Then they went into details about the possible motive in that Aruba trip. She said that there was a lot more tension and fighting. And then she went on to describe the fact that her uncle, who again she called JJ, asked Karen Reed to leave his home after that trip, that New Year's trip, and Karen Reed refused to.
The totality of, you know, to put a label on the whole thing, my opinion is that she's trying to get revenge.
Get revenge
Yes, get revenge.
on John
Yeah.
for what happened on New Year's Eve.
Yes.
All right, that's a sampling of the Commonwealth's case against Karen Reed. Still with us, National Trial Attorney Mackenzie Joy Brennan and former prosecutor Jeff Gold. Mackenzie, what stood out to you as the most compelling part of the state's case overall, the Commonwealth's case?
I mean, I do think the data is compelling. They're definitely more polished this time around, and they're giving information to rebut what the defense eventually says, which is, you know, that this could have been anything. It could have been even a slip and fall potentially. So I think that information is pretty powerful. I think the clips from her interviews are not her friend. It's tough because I think part of why she's so compelling is that she doesn't hide the bad facts, that she is a relatable person, she's real, she tells us what she's feeling, as opposed to defendants we see in national trials who kind of follow their lawyer's instructions and don't do these interviews. But I think that's what made a lot of folks like her. But it may be her downfall, because you hear just the snippet of her saying something like, the mom was yelling at the counter that it looked like he got hit by a car. That doesn't sound good. It does not sound sympathetic.
Yeah, Jeff, I mean, she didn't take the stand, but the jury got to know her, and Hank Brennan has played these clips throughout. Do you expect his close is going to be full of clips, the voicemails, John, you pervert, I hate you, and her, I hit him, I hit him, I hit him, I mean, because that is the Commonwealth's case, right? It's almost, don't worry about the experts, just look at her. And if you look at her, you might think that she did this.
Well, they're going to do that, Ted, but not quite that. They're going to rely on that data. I think they did a very good job of saying this happened and this is how it happened. Intent is another matter. That's where the Commonwealth is a little bit light, because they just don't have everything they would like. In terms of her statement, she says, and this was played before the jury, he didn't look mortally wounded as far as I could see. And then she continued, but I could have knocked him out cold and then whatever. That kind of stuff is really damaging to her. And she couldn't take the stand with all the different things that she said. I do think that the Commonwealth has always been light on whether this is a second degree. They will go to all the things you just said to try to prove the intent. But I think if they end up with the recklessness that they need for manslaughter, based on statements that I just read, I think they'll be happy, you know, given what happened last time. So, yes, they will talk about all that, but be very happy with manslaughter, I think.
Okay, let's get a break, and then let's turn our attention to the defense. Look back at some of the highlights from the defense's case. It was a much longer case this time around than in Karen Reed 1. That's next. Welcome back to Court TV Live. If you're just joining us, it's been an eventful morning up in Massachusetts. Both sides gathered along with Judge Cannone for the charge conference, getting those final jury instructions ready for tomorrow. Tomorrow, it's the closing arguments starting at 9 a.m. Judge Cannone wants everybody there early. She wants this jury to start deliberating in the afternoon. So 9 a.m. Eastern time, the closings will begin. Each side afforded 1 hour and 15 minutes to have final words for this jury before they go back and deliberate Karen Reed's fate. Last segment, we looked at the Commonwealth's case in the case against Karen Reed. So now, let's take a look at the highlights of the defense's case.
You'll see from the evidence in this case that this case carries a malignancy, one that has spread through the investigation, it spread through the prosecution from the very start, from the jump. And that cancer has a name. His name is Michael Proctor.
Good morning, Your Honor. Good morning, jurors. Keene PD had a male party that was discovered in the snow outside of a residence.
He was the lead investigator on the case officer, the architect of the entire prosecution. There's not a single part of this case, folks, not a single part that he didn't touch, that he didn't direct, that he didn't orchestrate personally.
Can you testify to the jury about who it was that brought this evidence into the lab?
All the items that are 7- was submitted by Trooper Michael Proctor.
Do you see a name associated with that evidence, Madam?
It looks like it could say Trooper Proctor.
Okay. Is there a reason that you want to try to distance yourself from naming Michael Proctor as the lead investigator in the case? Is there some reason?
I am not trying to distance myself. All I'm saying is the term that I use is the case officer. We're simply case managers. There's no leading investigation in any direction.
Michael Proctor is the very definition of the Commonwealth's case. And he's also their Achilles heel.
So these came from me. From all accounts, he didn't do anything wrong. She's a whack job. Yes, she's a babe. Weird Fall River accent, though. No ass.
Does it begin with comments from Mr. Proctor?
It does.
Could you read all of them, please?
These are not my words. I'm not really comfortable reading these.
Somebody in the group says, "Is that chick a smoke?" And then the same person follows up with a question mark. Accurate?
Accurate.
Mr. Proctor responds, E-H?
Yes.
Nut bag, as my chief would say?
Yes.
She's got a leaky balloon knot?
Yes.
In late January of 2022, what were your duties for the DPW?
I would plow.
How much of the front lawn of 34 Fairview could you see?
I could see all the way to the front door.
Did you see a 6'1", 216-pound man lying on that lawn?
No.
Did former Trooper Proctor inform you of the working law enforcement theory collision of a motor vehicle with a pedestrian?
He informed our office of that.
Did you come to a conclusion about the manner and cause of Mr. O'Keefe's death?
The cause was blunt impact injuries of head and hypothermia, and the manner was undetermined.
Do you agree with or concur with the blunt force head injury as the cause of death?
Yes, Mr. O'Keefe died from the blunt force head injury.
Do you concur with the diagnosis of hypothermia?
No, the body did not have any hypothermia.
On your direct testimony, you talked about injuries to the right arm of Mr. O'Keefe. Do you recall that?
Yes, I do.
And am I correct that you noted that there was a pattern to those wounds?
Correct.
You were not able to determine the cause of those pattern wounds. Is that correct?
That's correct.
Based on your review of all the materials, were you able to come to any conclusions or opinions about the source and nature of the injuries that you see depicted on that exhibit?
Those wounds were inflicted as the result of a dog attack.
Do you have an opinion as to whether or not the wounds that you see, the patterned injury that you see on Mr. O'Keefe's right arm, is consistent with an animal bite or claw marks?
Yes, it is, very much.
Karen Reed is not guilty of hitting John O'Keefe with her SUV. There was no collision.
We performed a drop test with a hybrid 3, so that's an instrumented anthropomorphic test device.
Another word or another phrase often used in association with ATD devices are crash test dummies, correct?
Correct, yes.
Why did you utilize 24 miles an hour for this test?
There is a triggering event. The speed is approximately 24 miles per hour, so we did a test at the end point, if you will, in that data set.
Were you able to reach any opinions or conclusions as to whether the damage to the subject tail light is consistent with striking an arm at 24 miles per hour?
Based upon the test results, it's inconsistent with striking an arm.
My conclusions with respect to the abrasions are that it was inconsistent with contact to the tail light, and that not only that those injuries are inconsistent, but you would expect additional injuries, likely fractures to the hand and or the forearm, depending on the actual speed of the vehicle.
Do any of the tech stream events or any of the data that you've reviewed, either yourself through Mr. Burgess's report, through Dr. Welch's report, do any of the data indicate that there was a collision on January 29th, 2022 at any time?
Neither of the events that occurred on that date were triggered by.
Received a call from the troopers assigned to the Norfolk District County DA's office.
Proctor called you. Did he say once he arrived at the location?
Yes, his intention was to retrieve a vehicle that he said was involved in a homicide.
Sergeant Barros, is this the condition of the right rear taillight when you showed up at the Reed household 15 in 2022?
Absolutely not. So this area was intact. This is what I saw was missing.
Did you tell those law enforcement agents on August 9th, 2023 that you saw Brian Higgins and Chief Burke together and alone with the SUV for a wildly long time?
That was my recollection at the time.
Do you want to be here today now?
I am put on the stand in a murder trial. I don't know why I'm here. I have no connection to this case.
You mentioned that somebody had suggested you be charged with perjury?
Yes.
Who did that?
One of the male members of the defense team. They were looking for me to say that I saw Higgins and Berkowitz in the garage with the car.
Did you share with them that that wasn't an accurate memory?
Yes.
How did they respond?
They became very aggressive, raised their voices, and the one word that I can very definitely remember is they said that they would charge me with perjury.
John went over to Karen and he gave her a kiss on the forehead. It just stood out to me. I was like, wow, that's the sweetest thing I've ever seen.
Did you have any concerns about Karen being able to drive that night?
Thing strange about her. Like
Okay, you may have noticed that the clock on the screen, the Lori Daybell case, has stopped that clock because the jury out in Arizona has a verdict. They are assembling everybody in the courtroom, so let's get just the fate of Lori Vallow in their hands. Stay with us.
Karen Reed is in the midst of the retrial of the century.
She is factually innocent. She's guilty.
There's something wrong in this county.
Come at me.
John O'Keefe was killed by that defendant, Karen Reed.
She's the victim of a corrupted investigation that was never about the truth.
Another big day here at the Dedham Courthouse.
Fight on. Nothing's breaking me, Matt.
You'll see it all unfold right here on Court TV.
The Karen Reed murder retrial. Live coverage today on Court TV.
Welcome back to Court TV Live. If you're just joining us, we have a verdict in the case against Lori Daybell. It's her conspiracy trial going on in the state of Arizona. The cult mom is accused of conspiring with her now deceased brother, Alex Cox, to kill her niece's estranged husband, Brandon Boudreaux. This just months after her fourth husband was shot and killed by Alex Cox, the brother, and just weeks after her two children went missing. Daybell has already been convicted in those other cases. We'll find out what the jury decided here. They deliberated for 44 minutes, as you could see, over the span of 2 days. Yesterday, they literally just walked into the room for about 15 minutes and then went home for the day. So they came back fresh today, and it hadn't taken them long, inside an hour, and they have a verdict. There is a court-imposed 5-minute delay in terms of the reading of the verdict, and they have not even started yet. So the judge is not on the bench yet. So we have 5 minutes in between when the judge takes the bench until we can show it because of the rules imposed by this court. So we'll keep you updated on when it comes through, but all parties are being summoned, including Lori, and we will know soon what this jury decided. As we wait, let's take a look back at the case against Lori Daybell.
911, where's your emergency?
Someone just shot my window.
Okay, someone shot at your vehicle?
Yeah, and it hit my window, it shattered my driver's side window.
October 2nd, 2019, Brandon Boudreaux called 911 after someone shoots at him as he was pulling into his driveway in Gilbert, Arizona.
I was just pulling in. I noticed a green Jeep Wrangler, had a Texas plate. So as I was kind of pulling in, they lifted their back window.
Okay.
I saw a muzzle. They shot.
Boudreaux was not hurt in the incident, but it was the beginning of an unimaginable chapter in his life, linking him to the Lori Vallow Daybell path of destruction.
It just makes you sad. You know, like a lot of people you care about aren't here anymore because of these ideas.
Brandon Boudreaux was married to Lori's niece, Melanie, for 10 years. They had 4 kids and had a close relationship with Lori and Charles Vallow.
We spent holidays together. When they lived close to us, we probably see each other once a month, and then we do trips together. We went to Disneyland a lot together.
In late 2018, Brandon and Melanie's marriage fell apart, as did Charles and Lori's. This came shortly after Lori and Melanie met Chad Daybell.
Their focus is just so much on the end of the world and, you know, this idea that it's coming.
After Charles Vallow was shot and killed by Lori's brother, Alex Cox, Melanie moved to Idaho with Lori and her kids, Tylee and JJ.
So they shot, then what happened?
It hit my window, and instead of turning in, it scared me really bad.
He believes that Alex Cox was the person who fired that shot, and he knew that Alex Cox was kind of the family hitman.
Lori Vallow Daybell is facing charges of conspiring with her deceased brother Alex Cox in the attack on Brandon Boudreaux. She has pled not guilty and will be representing herself at trial.
And she did represent herself at the trial here. Again, if you're just joining us, the verdict is in. A jury has come to a verdict in the case against Lori Daybell. 44 minutes is all it took them. Let's bring in National Trial Attorney Mackenzie Joy Brennan and former prosecutor Jeff Gold. 44 minutes. She's representing herself. I can kind of feel where this one's going, but you never know. Jeff, your thoughts?
Well, counter to that, I will say over 40 years ago, I had a trial as a prosecutor where the jury came back in a half hour. And of course, I was a young prosecutor at the time. And the judge said, well, of course, you know that means it's a conviction. It was an acquittal, so you never know. However, she had a fool for a lawyer. She called no witnesses. She argued with the judge. Got removed. I think I agree with you in this one.
Well, yeah, look at OJ. I mean, that one, that didn't take long after 9 months of trial, and they came back with the acquittal as well. Mackenzie, to Jeff's point, you represent yourself. You're putting yourself behind the 8 ball. Her motivation to do so, I personally feel it was just because it was fun and nothing else to do. She's rotting away. What's your take on that decision and her ultimate performance?
I honestly would kind of agree with you. It's funny, I was going to give that Lincoln quote that whoever represents themselves has a fool for a client. But I got that impression during her testimony, and she seems to express a lot of self-pity in her closing as well. It was kind of centered around, I'm no stranger to hardship, and then those motions about her being sick. It was very melodramatic, and I say that with all due respect, but I think she likes to hear herself talk, and I think she's probably light on the attention and pity that maybe she got when she was a sort of matriarch in this pseudo-cultish environment that she'd created. And so now it's a lot of harsh reality coming home, and I think that this was her last stand to kind of control the room.
Yeah, let's listen to a little bit of Lori, her closing, to what you just referenced, just meandering and basically saying, I've had family tragedy too. Take a listen.
It's 2019. Brandon Boudreaux decided that I was responsible for his family tragedy. And I'm really sorry that he feels that way.
No, Your Honor, I'm going to object again to testimony.
Just her closing, Jeff, was riddled with objections by the state. There was just no flow. She didn't harp on reasonable doubt, which you could have argued here, because there wasn't a ton of evidence against her. At the end of the day, though, the other crimes that she was involved with, and Brandon Boudreaux taking the stand and saying, when I got shot at, the first person I thought of was Alex and Lori. Was this over before it started?
Well, I mean, I don't know what I would have done with it if I was a defense attorney, but when your attorney is a crazy person, yeah, I mean, it was over. You know, the clip that you played was very, very important, because what happens in a case like this, where somebody represents themselves and they're going to do a closing argument, what they try to do is testify. They try to do what they can't do because they're not sworn on the stand. And that's what she tried to do here, just making the point that she didn't know what she was doing. And, you know, I can say, we all say, you know, the old expression about the fool, but my experience is that people are a lot less than a fool. They're really crazy when they represent themselves in a case like this. You know, it's not a speeding ticket, you know. Sure, got a speeding ticket, represent yourself. It's a murder case.
Yeah, reminds me of Daryl Brooks.
And I think that
Milwaukee.
I think every juror knows that.
Yeah, absolutely. We need a break here. Thank you both. Again, we have a 5-minute delay. The judge, I don't believe, has even taken the bench yet, so we're a little bit away, but we'll have the verdict when we return. Stay with us.